How to do your own divorce, step 3. Hello, I'm John Hind, author of the Divorce Manual. Responding to a divorce application. In this video, I cover completing your divorce response and whether you can dispute or delay divorce proceedings. Now, the first thing to note is that if you are the respondent, you have 14 days from the date you receive the divorce application to file your response. On paper. If you're responding on paper, you must use Form D10, which you can find in the resources section to Chapter 6 of the Divorce Manual. Online. If you are divorcing online and you are the respondent because your former partner is the sole applicant, you'll be provided with a 16-digit reference number and an 8-character access code in an email and letter, which invites you to the online application so that you can complete your response. Disputing the divorce. Now, there are only very limited reasons for disputing the divorce application. Please remember that you're not entitled to dispute whether the marriage has broken down because there's no reason for the applicant to prove that the marriage has broken down in the first place. Also, if you do wish to dispute the divorce, this cannot be done online. It has to be done on paper, and you'll have to complete Form D8B and pay another application fee of £245. You must file Form D8B at court within 35 days from the date you receive the divorce application. If you don't, your spouse will be able to continue with the divorce as if you've never disputed it. Now, you can only dispute the divorce application because, for example, number 1, you dispute that the Court of England and Wales has jurisdiction because, for example, neither party lives in or has any connection with England and Wales. Number 2, you dispute the validity of the marriage because, for example, you and your former partner never entered into a legally valid marriage. Or number 3, the marriage or civil partnership has already legally ended. For example, if the marriage has already been brought to an end in proceedings outside England and Wales. It may also be possible to challenge divorce proceedings for reasons such as fraud and failure to comply with the correct procedure. Delaying divorce proceedings. Form D10 question 7 asks whether you intend to ask the court to delay the divorce until it is satisfied with your financial situation. If you do, you'll need to complete a separate form and ensure that the court receives it before the application for the final divorce order is made. When making its decision about whether to delay the divorce, the court will take into account all the circumstances and your financial position should your spouse or civil partner die before you and before a final financial order is made. The court may not delay the divorce if it's satisfied that your spouse or civil partner will or has made appropriate financial provision for you. In my video about step 2, I referred you to where you can find in my divorce manual information about sorting out your own finances with your former partner. Essentially, the divorce process builds in 5 months from the date of the divorce application to the date of the conditional divorce order to reach a mediated financial agreement, which you can then ask the judge to make binding once you have your conditional divorce order. There should be plenty of time if you use a skilled mediator and work together with your former partner in mediation, and it would mean no delay with a divorce is necessary. On to step 4, applying for the conditional divorce order. Thanks for watching.